I was taking a look at the Illinois so-called assault weapon ban / magazine ban. And there's an interesting nuance that the anti-gunners have come up with in the statute dealing with the use of magazines that hold more than 10 or 15 rounds, depending on if we're talking about a long gun or a handgun. Very interesting. I want to talk about it, flag the issue, and explain to you how to respond going forward. Stay tuned. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and author of the brand new best-selling book, Disarmed: What the Ukraine War Teaches Americans About the Right to Bear Arms. Check it out. It's not only available on Kindle, but also an audiobook in addition to paperback. Check it out. All right, folks. I want to flag a nuance about this Illinois assault weapon ban / magazine ban. Obviously, we know this ban is, at the end of the day, set aside the propaganda terms, a ban on semi-automatic rifles and magazines that hold more than 10 rounds for use in long guns, like rifles, and magazines that hold more than 15 rounds for use in handguns. Now, here's the interesting twist that I've just focused on, because I've been handling the big picture, because to me, these laws should be just struck down as unconstitutional. Hopefully the Seventh Circuit Court of Appeals does this. And if they don't, then hopefully the Supreme Court will step up to the plate and solve what is an obvious and easy problem as I see it, but only time will tell. So here's the interesting nuance about how Illinois has essentially prevented the use of magazines that hold more than 10 rounds or 15 rounds for self-defense outside of the home. Specifically, I want to read the part of the statute because a lot of people don't know this. To begin with, there is allegedly a grandfather clause involving magazines. And to remind you, Illinois passed a law that says you can't have a magazine more than 10 rounds. No, you can't buy a magazine with more than 10 rounds for a long gun. You can't buy a magazine for more than 15 rounds for handguns going forward. However, it went on to say that there's sort of a grandfathering clause that says that if you already own one of these magazines that holds more than 10 rounds or more than 15 rounds, at the time of the effective date of this law, this Illinois law, then you are allowed to possess them. You don't have to throw them out or get rid of them. Okay? But it still restricts your ability to use these for self-defense. And what do I mean by that? So it says you can keep these magazines if you had them before a certain date, but there are limitations. And I'll put a link to the relevant statute down below so you can check it out yourself. What it says is that under subsection C, it does not apply to a person's possession of a large capacity ammunition feeding device, which is a modern day semi-automatic magazine, if the person lawfully possessed that large capacity ammunition feeding device before the effective date of this act. Okay? Provided that, and here's the proviso that is key. So they giveth the ability to keep those magazines that you already possess, but then they taketh away as follows. It continues on to say, provided that the person shall possess such device only, and here's the exceptions, and follow me carefully on this, only if, number one, those magazines that have been grandfathered in can be kept, one, on private property owned or immediately controlled by the person. So if you have them in your house, you can keep them. Number two, you can keep them on private property that is not open to the public with the express permission of the person who owns or immediately controls this property. So presumably if you go over to a girlfriend's house or a friend's home and they know you have this magazine on you and they give you consent to be there, well, that's okay. So you can have it in your house. You can have it at a friend's house, provided that they control that property or own it and give you permission to be there with that magazine. It's more than 10 rounds or more than 15 rounds. The third is they also say that if you're on the premises of essentially an FFL, if you're on the premises of a licensed firearms dealer or gunsmith for the purposes of lawful repair, you can have it there. So you're bringing it in to get fixed or whatever it is, you can have it on that premises. That's the third thing. Fourth, you can have the magazine that's more than 10 or 15 rounds if you're engaged in the legal use of the large capacity ammunition feeding device, use of magazine, at a property that is properly licensed firing range. If it's a properly licensed firing range or sport shooting competition venue, you can have your magazine there. So presumably you can bring your magazine there if you want to shoot more than 10 rounds. You can have it there according to that proviso. And last but not least, you can have your magazine that holds more than 10 rounds or 15 rounds while traveling to or from these locations, provided that the magazines are stored, unloaded, and enclosed in a case, firearm carrying box, shipping box, or other container. I mean, you have to have it kind of like locked away somewhere and unloaded. So obviously, this is all entirely stupid and almost certainly unconstitutional. Nevertheless, the way it is right now, I wanted to flag for you that right now, what is clearly excluded, if you look at those provisos, what is not found there? What is not found there is you cannot use a magazine more than 10 or 15 rounds, even if it's been grandfathered in, meaning you had the magazines before the effective date of the law, and you're lawfully allowed to have them in your home. But the one thing you're not allowed to do under these 5 provisions, these 5 exceptions, is put it in your firearm and carry it outside the home for the purposes of armed self-defense as contemplated by the right of the people to keep and bear arms and NYSERPA versus Bruin. They specifically excluded that. So even if your magazines are grandfathered in, you still can't use it for self-defense outside of your home or presumably your friend's home if you have permission to be at your friend's home with a magazine. You see what they did there? So this is very important for those of you out there in those terrible blue states. And I feel sorry for you. But you got to watch this little game they're playing that Illinois just did. So I'm alerting you to this thing of how they're trying to, even if they let you keep the magazines, they prevent you from using them in the most fundamental way, which is for self-defense, specifically outside of the home. All right. Now, I'm just going to give you a quick couple of reasons why this is likely unconstitutional. My most important thing about this video was just flagging the fact that this happened so you can spot it in the future where the anti-gunners are going to go. But the few things is, first of all, obviously we know that magazines are arms and thus they should be protected under the in common use test for lawful purposes. We know they're arms for many reasons, one of which is they're an essential component of a modern semi-automatic handgun, and they're an essential component of a modern semi-automatic rifle. We know that semi-automatic handguns are protected not just in Heller, but also because of Catano. Remember, the entire dissent in Heller was all about semi-automatic handguns that, of course, the majority in Heller talked about saying protected. Of course, Justice Alito in the concurrence talks about how modern-day firearms are protected. That's obviously the case. We're not limited to single-shot pistols or dueling pistols or muskets at the time of the founding, any more than we're not limited to quill pens and ink to communicate with others under the First Amendment. So the first thing is these are obviously modern firearms and magazines are essential for this. The second thing is that Bruin specifically says that any item that is used to facilitate armed self-defense is an armed. Obviously, a magazine helps facilitate armed self-defense because it helps with you use a modern-day firearm. And last but not least, keep in mind that NYSERPA versus Bruin talks about, the right to bear means the right to carry. And obviously, if you're not allowed to carry these magazines for self-defense, your right to keep and bear arms is being violated. And the last point I want to make, and this is kind of a little geeky point, so just bear with me just for a second, because you need to think about this for a second. If you think about what's going on here, the ban on these magazines that hold more than 10 rounds for long guns and 15 rounds for handguns is a form of a gun ban, not just an arms ban. Right? We could agree that a magazine is not in and of itself a gun. It's an essential component of a modern firearm. But with that said, let me step back a little abstract here. Not that hard, but you got to think for a second. If you think about it, the magazine that holds more than 10 rounds allows a firearm to shoot more than 10 rounds without having to reload. So if you ban magazines that hold more than 10 rounds, what have you effectively done? You've effectively banned in that jurisdiction rifles, in the context of this law, rifles that are capable of shooting more than 10 rounds without reloading, which means that you have a ban on an entire category of firearms, specifically the category of firearms that hold more than 10 rounds and are able to fire more than 10 rounds without having to reload. So because you have just banned an entire class of firearms that are in common use, i.e. firearms that hold more than 10 rounds without having to reload, or in the case of handguns, handguns that can fire more than 15 rounds without having to reload, you have effectively a firearm ban case. Not just a magazine ban case, you also have a firearm ban case, which is no different than Heller versus the District of Columbia in 2008, where a ban on all handguns in the District of Columbia was viewed as unconstitutional because handguns were in common use in America. Remember, the standard is not in a given state or a county, it's America, because the Second Amendment is an American right that applies to the entire country, not just the plains of Iowa, but also to downtown Manhattan in New York City. So it applies to the whole country. So when you look to in common use, you look to the whole country, as opposed to what some of the anti-gunners have tried to say is you only want to see is that type of gun in common use in Manhattan. It's totally irrelevant because it's a Second Amendment, it's a national law, it's a national constitution. You look at the whole nation to reach conclusions about it, for example. So again, so I just want you to understand that this ban on the use of magazines that hold more than 10 rounds or more than 15 rounds in Illinois does exist. That the way they pretend that it's been grandfathered in to sell it to you is really BS, because although it's technically grandfathered in, you can't use it outside the home for self-defense because of the way they wrote the law without committing a crime. And of course, as we've talked about before in this video and others, a ban on these magazines is unconstitutional because it's a ban on arms in the context of magazines. It's also a ban on a type of firearm specifically, i.e. firearms that fire more than 10 rounds or 15 rounds without having to reload. So, okay. Anyway, I hope you learned a little bit something today. This is a little bit shorter video, laser focused on a particular component of this Illinois law. I'll put a link to some of the stuff down below. You can check it out. And again, if you have any questions, feel free to send comments. I don't always get to them because there's so many of them, comments and emails and everything else. But I try to hit a few every day as best I can. So, okay. If you haven't subscribed to the 4 Boxes Diner, please do so. We'll see you again here at the 4 Boxes Diner.
Orders up. Table 2A.